Alrighty, folks, looks like we are live. I am George, founder of Solo. I'm here with my friend Greg Anjewierden. Greg, how's it going?
I'm doing good. Thanks for having me.
Fantastic. Folks, Greg is a licensed and practicing attorney. He used to work as a debt collection lawyer collecting unpaid medical debt. With his experience, Greg knows all the inner workings of the debt collection litigation system and how it can be very unfair for people who can't afford a lawyer. Greg is also the founder and CEO of Debt Brief, a company that helps people who are sued for debt with consulting, legal representation, forms, courses, and other resources. Folks, if you have a question for Greg or for me, call into the Debt Hotline at 801-613-8181. You will talk with our wonderful assistant of the show, Hannah, and she will let you know how things go and then plug you into us. All right. So it's a fun time. And just go ahead and call in 801-613-8181. We are doing tonight Q&A, just generally talking about when to fight or settle already. We have a first question here from Nathaniel in Ohio. I owe $1,700 to Capital One / Discover based on credit card debt from 2020. Should I settle or fight? And if I settle, what is a reasonable settlement? They offered $1,545, but I can't pay that with current medical expenses. Credit card became delinquent due to COVID 2020 and my job loss. Any advice is appreciated. Nathaniel, if you're watching live, go ahead and let us know in the chat. Greg, what do you think?
Okay, so I have a couple of thoughts on this one. I mean, if you're talking about a debt from 2020, we don't know. I don't know what state this person's from. It depends on the state. You may or may not be outside of statute of limitations. It's at least worth looking, and I know Solo's got a good calculator there. So I'm going to assume that that's not an issue, that it's within the statute of limitations. I think the thing is on fighting versus settling is you've got to figure out if you've got a basis to fight, right? So if Capital One is suing you for this debt, find out what proof they have that you owe the debt. My experience with Capital One is they're suing directly. They're not selling their debts a lot of times to like a junk debt buyer. So they don't have that issue of having to prove the chain of custody of the debt. So it's really going to come down to, do they have proof that you had a credit card with them and that you didn't pay it? So to say, like, should I fight or should I settle? Like, that's really the question you should be answering is, does Capital One have the proof they need to show that I owe this? If they don't, then maybe I want to fight it. If they do, then yeah, I'm probably settling. I mean, George, you guys probably get this question even more than I do. Like, what's a reasonable settlement? And my experience has been, like, that's an impossible question to answer because every single case is different. I've seen cases where they're like, you know what? Like, we understand your situation. We're just going to let it go and not collect anything. And then I've seen some where they'll say, oh, you owe $1,700 and attorney fees and interest is continuing to accrue, so we'll settle for $1,800. Like, and I've seen everything in between. So for me, it's really comes down to, well, figure out what I can afford, both as a one-time payment and a payment plan. And if I can't get them down to that number, then I'm just going to fight it as best I can, understanding that the worst case scenario is they're probably going to end up garnishing wages. So, it's like, well, I can't afford it. Well, worst case scenario here is they're going to take 25% of your take home pay. So can you get a deal that gets you out of that? If not, that's kind of the situation that you're in, remembering that you can always settle the case later, right? Like, if you can't settle it now, that doesn't mean that it can't get settled after they start garnishing wages or try to garnish your wages. The other thing I'd say is, like, sometimes you can do a good job of negotiating on your own, but like solo settle might be something to take a look at too, because, I know you guys have, like, build relationships with these common creditors, that there might be you might be able to do a better job negotiating on behalf of this person than they can on themselves. So those are my thoughts.
Yeah, that's for sure. All of that sounds on point, right? And as far as the settlement range, right? The range is very broad, right? Yeah, we've seen anywhere between 0% to 100% of the balance. Right? We've seen people settle for nothing, where the debt just gets forgiven. We've seen people pay full balance, and the average is 45% pre-lawsuit settlement, and then 80% or maybe like 70% after you've been sued. So 70% of the balance of the lawsuit. Those are the averages, but this is one of the cases where averages are kind of misleading because uh, the range is really all over the place. Yep. Looks like we have a live caller. We got Wayne. Wayne, I'm going to plug you in here. Wayne, how's it going? This is George. Are you on, Wayne? We cannot hear you yet, Wayne. I'm going to give Wayne a second to figure things out a little bit more, and hopefully we can get him back in. Thinking some more about Nathaniel. He says Capital One / Discover. Capital One and Discover merged, right? Is that right? That actually go through, Greg?
I haven't kept up on that, so I don't know where that's at. I mean, in some sense, it can matter to you, right? Like, if it's it, take a look at who the plaintiff is on the actual lawsuit, right? And like that's the person suing you, and that so if it says Discover needs to show that Discover has the right to sue. If it says Capital One needs to show that Capital One has the right to sue. And if there's some kind of merger or purchase, something like that, then they technically need to provide proof of that in order to demonstrate that the new entity owns the debt. So it may be a step that, it's a technicality, but like if their lawyer's not doing a good job, and I could see it on a case with that small of a dollar amount, if they don't show up prepared to prove that issue, there's a chance you could beat them on a technicality.
Mm-hmm. Yeah, so it looks like Discover and Capital One merged as of April 2025. So yeah, I think that could play, could factor into people's lawsuits situation as far as what name you see on those lawsuits. Capital One is a bank that will oftentimes file its own lawsuits, and they're going to come up as one of the larger plaintiffs across the nation. So that will probably feed into Discover Bank here as well. And oftentimes, it's not to say we don't see people settle with them a lot, right? We see people settle with Discover and Capital One frequently, and oftentimes they're willing to give a good deal to get a consumer back as one of their customers. All right, we got a question from one of our listeners who called in ahead of time. So I'm going to bring that up. This is Samantha.
Hi guys, my name is Samantha and I am requesting some assistance for a pretrial hearing that I am supposed to attend on Thursday. I was recently contacted about this $2,000 debt in August. I received a pre-legal notice from PayPal / Synchrony where the debt, I guess, originated. And in that same bundle of mail, I received a notice from the lawyer, I guess, acting on behalf of PayPal or whoever acquired the debt. So I immediately drafted a formal response for request for verification and proof that I own the alleged debt. I sent it first class mail, so I knew that they received it September 6th. I thereafter received a summons for a pretrial hearing on October 30th. So I was under the impression that they had already filed the lawsuit against me regardless of what I did. And shortly after I received the summons, I received the packet of information from the lawyer's office. The party suing me is Credit Core Solutions, who I suppose had purchased the $2,000 debt from PayPal or Synchrony. This alleged account is several years old. I believe it was opened in 2018. The original balance was over $1,000, but with interest in 2020, when I had a bunch of issues paying my bills due to cut hours and all the same problems everybody was facing, I just fell behind on payments. And originally I was paying for this contract using money orders because they would not accept payments from my PayPal debit account. So a lot of things have changed since then. And since Credit Core acquired the debt, I didn't even know that they had it. I had never received a notice that Credit Core had this debt. They bought it. I'd never received any contact on where to make payments since PayPal sold it to them, which they allegedly did in 2022. I never heard anything from them. So I am asking, how should I prepare and proceed with this pretrial for the best outcome against Credit Core Solutions? There may be some statute of limitations. I am here in Florida. I have had other accounts and collections. I am currently 10 grand total in debt, but I am making payments toward a lot of that debt. And this one just kind of came out of nowhere. It wasn't on my credit report, and surprise, after building up my credit over the last 5-6 years, now it's gone into the pooper again. So any help or advice for my pretrial hearing on Thursday would be awesome. Thank you.
Can you hear me, George? I can't hear you. I could hear her.
Oh, sorry. That is Samantha. Thanks for calling in, Samantha. Sharing with us your situation. Greg, what do you think?
Okay, there's a lot there. The first thing, she asked about statute of limitations. I think Florida on written contracts 5 years. So you want to take a look at that. I think the thing that's important to remember on statute of limitations, it's not when the debt's open, but when it goes unpaid. So like when you allegedly breached the contract, that's when you want to calculate it from. So that's the first thing. Take a look at that. The second thing is she's like, okay, how do I prepare for a pretrial hearing? So a pretrial hearing really just means that the court is holding a hearing before the trial occurs, right? I mean, that's, I guess, obvious in the name. But a pretrial hearing can be any number of things. So really, without looking at the court docket, it's hard to say, or the notice, it's hard to say exactly what's going to happen at this hearing. So you've got to kind of be prepared for almost anything. The only thing that we know isn't going to happen at this hearing is there's not going to be an actual trial. So if, for example, the plaintiff has filed some kind of motion asking the court to do something, maybe it's a motion for summary judgment, then that motion could be argued and decided at the pretrial hearing. The other things that can commonly happen at pretrial hearings is sometimes the judge just wants a status update and to schedule trial. So you want to be prepared and say, what else do you need to do on your case to get it ready for trial? Let the judge know, and then be prepared to give dates you're available to schedule trial if the judge wants to do that. Finally, and I've seen this actually a lot, sometimes plaintiffs will request a pretrial hearing even when they don't need any help or to address anything with the judge, because what they're hoping is that that the hearing gets set and you do one of two things. Either you don't show up at that pretrial hearing, and when you don't show up, they will ask the judge for a default judgment. Or if you do show up, they're going to be prepared to negotiate the debt with you. So I would definitely, you've got to show up at that hearing. If you don't show up at the hearing, there's a real good chance you're going to get a default judgment. And when you do show up, you should be prepared to negotiate. Now, I'm not going to tell you what that negotiation has to look like per se, but like, be prepared. They are probably going to want to discuss negotiation of the debt with you. So I don't know if you have any other thoughts. I can keep going on this if you want me to, but I mean, as
No,
far
it's
as
a
like
great thing.
getting ready for the pretrial hearing, those are the
Right.
things that I want to be prepared for. Is what else do I need to do on the case before trial? I need to be prepared to give dates to the judge that I'm available for trial. I need to make sure I'm there, and I need to be prepared to negotiate.
Yeah. I'm a little bit fuzzy how she got to a pretrial hearing. She doesn't mention filing an answer.
Yeah. Yeah. And so, it can be something like if you don't file an answer and they've filed a motion for default judgment, sometimes, although judges don't necessarily have to do this, sometimes they'll set a hearing anyway to like give the person another
Right.
chance. So yeah,
Yeah.
that's a great point. If you haven't filed an answer, I would get that answer filed before the
Yeah.
pretrial hearing. So you can show up and say, hey, I know it's late. I didn't get it done, but I've got it done now.
Right. Yeah. Yeah. Samantha. Yeah. Florida's usually kind of known for like a rocket docket. They're usually moving through things pretty quickly. Usually, how a case progresses is you get summons and complaint in the mail, then you respond with a lawsuit, with a response to the lawsuit, and then after that, it goes to a pretrial hearing, and then after that, it can go to like a trial before the judge. Usually, there's no jury in these situations. You wouldn't. Yeah, if you haven't filed an answer, you should file an answer. Sometimes people misunderstand and file a debt verification letter. Uh, people have different takes. Solo, we generally don't encourage doing a debt verification letter. You can just, and if you are being sued, debt verification letter is not a response. It is not an answer to the lawsuit. So you want to file a response to the lawsuit for sure if you haven't done that
I would
yet.
add to that a once you're sued, a debt verification letter is kind of useless because what you're doing if you send that before the lawsuit is you're like, hey, send me what proof you have that I owe this debt. But once they sue you, they've got to go into court and prove that you owe it. So it really doesn't make sense to say like, hey, send me your proof. They're going to have to produce that proof at some point in the lawsuit anyway.
Right.
I
Right.
I
Yep.
once you don't waste your time with a debt verification letter.
Yeah. Yep. And one last thought, Samantha. It looks like it's a 2K debt. Maybe it doubled from 1,000. If you can get this settled and wrapped up, that'd be definitely your best choice. You have 10K in debt. The lawsuit debt becomes your priority, even if it's not your largest debt. Once you get sued, it's your priority. If you can funnel your money towards just getting this paid off, get on a payment plan, and get that wrapped up, that might be like the easiest path here. But you should definitely respond to the lawsuit, and then you can try to get it settled. We've got Jim Cardozi here on the line. Jim, I'm going to route you in, and then we have Wayne, who's up next after that. Jim, how's it going? This is George.
Good. How are you, George? Can you hear me all right?
Doing good. Yeah. Tell us about your situation.
Cool. So I used Solo to file my answer, several months ago. I've had 2 pre-trials. The plaintiff has put forth a couple different very young attorneys. And in both cases, I said, look, guys, I need chain of title. I need proof that I owe you this debt. I need a purchase agreement. I need for you to prove that I owe this because you haven't provided enough information. The last time that we had our pretrial, the judge was like, okay, well, you know what? Let's just set a trial date. So the trial date's next week. And, in looking back and kind of reviewing everything, I firmly believe I could have probably issued a motion to dismiss for either lack of standing, because I have not gotten chain of title, for poor service, because they sent me, and by the way, I'm in Ohio, because they sent me a certified mail, document that they never knocked on the door. They never asked for signature. It was just left in the mailbox. The return receipt, or whatever you want to call it, for the certified mail was still attached to the letter. So I probably could have claimed that I never even received it. But long story short is, I'm planning on going in. I mean, I know that Portfolio Recovery files about 500,000 cases a year, and their whole, being a debt or a junk debt buyer, their whole ploy is, 90% of the people are not going to show up and we'll get a default judgment. In my case, I'm not going to screw around with them. I'm just going to go in and I'm going to say, look, I've asked several times and I put it in writing. I've sent it certified. I'm looking for proof that I owe this debt. I'm looking for, again, I'm looking for chain of title. I'm looking for purchase agreement, which I know, in fact, they probably don't have, and they have not joined the original creditor, which was Citibank. So does that sound like that's a good strategy, or should I be thinking in a different direction?
Greg, go ahead, Greg.
Yeah. Okay. So I got some thoughts here. First of all, I just made some notes here of some things you brought up. I'll try and hit as many of them. So you said, you probably weren't served correctly. That may be true, but once you filed an answer, you've basically said, well, I'm here anyway. So like I would kind of forget the argument if I wasn't.
How did they serve you, Jim?
They sent me, again, I'm in Ohio. They sent me a certified letter, and the return receipt was still attached to the certification, notice. They never knocked. I didn't sign anything. It was just really, really bad.
I wouldn't say that you like can't argue it. It's not going to be your best use of your time in front of the judge, right?
Yeah.
Because he's going to say, well, we're here. You got notice. So like, let's move forward. Right?
Yeah.
Okay. Now, as far as like the requests, it sounds like you just like sent them certified letters asking them for like purchase agreement, or did you do this in like formal discovery requests?
I did it in my initial, well, no, I take that back. Like I said, I used Solo for my answer. And then in my 2 pre-trials, I said, look, this is what I need. And I said it in front of the judge. The second pre-trial, the judge was like, oh, okay, well, I didn't have in my notes that you requested that. Okay. And I said, so help me out here, Judge. Do they have to respond like within 30 days, or what's the deal? But they have to respond, right? I mean, if that's their smoking gun, shouldn't they produce it? And I've yet to receive anything.
Yeah, typically when you ask for that stuff as part of a lawsuit, you do it formally through like a specific form called like a request for production of documents. So if you didn't like issue that form, the judge may come back and say, well, you didn't actually follow the proper procedures to request it. Now that's okay, right? Because this is still going to be your argument when you go to trial, because you're correct. Well, now because we didn't issue it maybe the correct way and they haven't provided it, it's still going to be your argument at trial, which is they've got to prove 2 things. Number 1, that I owe the debt. Where's their documentation that shows that I owe this debt, right? Mm-hmm. I forget what kind of, was it a credit card? Is that what you said?
It was originally a Citibank credit card, yeah, from like 2019.
So like, where's the credit card agreement? Where's like maybe the form that I filled out online? Where's the individual statements that show the purchases you claim have not been paid? This kind of stuff. And then, like you mentioned, where's the purchase agreement showing that the current plaintiff purchased the debt from the original creditor? And like, where are these things? So if they haven't produced them to you, so they very well may not exist. And that's going to be your argument when you go into trial, is that they can't prove these 2 things, that I owe the debt and that they own the debt.
Yeah. Yeah. I mean, they originally sent me some credit card statements from Citibank that were like from the date that they claimed they purchased this, right? But not back to day one.
Balance, right?
Say again?
It probably is like one line that says like past due balance. And then
it had that. It had, additional fee. I mean, it was an actual picture of a credit card statement, but it was a Citibank credit card statement, and it was from the date that they claimed that they purchased the debt. And I've asked, I said, well, if you own the debt, I want to see it all the way back to day one. I want to see all my payments. I want to see the whole account history.
Now, that's exactly what I would do. I think the thing you got to remember, though, is you got to think about like the scales of justice, and they're going to put all their proof here, and you're going to make your arguments, put your proof here.
Yeah.
It's not going to be like, well, they didn't produce all that stuff going back to the beginning, so I should win. It's when the judge looks at the fact that they haven't produced it all the way back to the beginning, is that going to be enough to tip it in your favor? And that I don't know the answer to. That's going to be up to your individual judge, right?
So Jim, how much are you being sued for, Jim? How much are you being sued for?
It's like $9,600.
$9,600, and this is with PRA.
Yeah.
Portfolio Recovery Associates. So they bought the debt. Are they the ones suing you too, or are they using a law firm?
It's interesting. They sent me information, and they're using a company called Javich and Associates out of Cleveland.
Mm-hmm. Okay. Yeah. And you're in Ohio?
Yep.
Okay. Yeah, so we help a lot of people in Ohio, right? So you're on the first track. First, I want to applaud you for responding to the lawsuit with the data answer with Solo. And then what a lot of people do in your position, if they're familiar with the debt, they'll oftentimes just go and settle the debt with Javich Block, right? So you can use Solo Settle to make an offer to Javich, get it resolved. Maybe depending on the situation, you can get any kind of settlement, right? Their settlements range from like 20% to 80%, like I was talking with Greg earlier.
Yeah.
And you can just pay off this debt at a discount. You can get onto a payment plan where maybe you're paying $200 a month over however many months, or maybe you can pay it off in like 3 payments, just depending on your financial
Right.
situation. What do you think about that path? I think you have the path where you can
You know,
take it to trial. What do you think about the path of settlement?
if I settle, I'm agreeing to. I mean, I'm not opposed to settling, and that's what Javit has wanted to do all along. Every young attorney they've thrown at this, they were like, yeah, we'll talk about settling. Well, of course, right? Because they can't prove what they need to prove. I think we know that, but it's the risk I take.
Right. Yeah, something to point out, right? That's an important note. Just one way or the other is when you go to trial, it's a winner takes all system, right? Settlement before trial is usually a split the difference, right? It's like a split the difference, like both sides kind of win, both sides kind of lose. When you go to trial, it's a winner takes all. One person wins big and one person loses big, right? You could end up paying more than you're even like being sued for sometimes in trial. Or like a judge can like treble damages sometimes. I mean, it's probably not going to happen in your situation. But also you could just totally get off the hook and like end up having this debt fully resolved. All right, so that's something to think about. Jim, thanks for calling in.
Appreciate it.
Appreciate it. Yep. Good chatting with you. Take care.
Yep, you too.
All right, Wayne, we're going to plug in Wayne. Wayne, how's it going? This is George. Oh, we're not hearing you. We're seeing you. We're seeing your video, Wayne. We're almost there. Almost there, but we can't hear you. It doesn't look like you're clearly muted or anything. Are you on your phone? All right, Jim, we're going to have to let you figure this out a little bit more. Feel free to, maybe you can message us in the chat too with your question and we can get to you there. All right, we got Shubha, who's also calling in. Shubha, go ahead and unmute yourself if you are here, Shubha. Shubha. We can't hear you. Shubha, if you're here, we can try again in a second. Wayne, any luck now? Still can't hear you, Wayne. All right, we got a question from you here. So let's take Wayne's question here in the chat. My wife and I are being sued over a timeshare we have never used for $6,792. Sorry to hear it. Sorry to hear it, Wayne. I hear about the timeshare scams. Sounds like you are in one, so that's a bummer. They're suing me for fees they transferred to a MasterCard. We asked repeatedly over 6 years to exit the timeshare after 1 month. So after the first month, sounds like you wanted to bail. I hired a company for $4,000 to exit the timeshare. We have told them for 6 years we would never pay them. What should we do? Wow. So that's a bummer. So you got into a timeshare after month 1. You bailed. Now they've been hounding you for 6 years. Now they're suing you. That's sounds like a real bummer. What is the timeshare, Wayne? Tell us what the timeshare is in the chat. Did you ever? You said you never went to the timeshare. Just tell us who the timeshare is. Greg, what's your take? Ever deal with any timeshare issues?
Yeah, timeshares are tough because usually those contracts are written pretty well, right? Like they're hard to argue to get out of. Now, some states are going to have, timeshare specific laws to help people avoid those kind of things. So, I mean, that might be something to look into. Is does your state have specific laws that help you to get out of timeshares? As far let's assume not, and it's just, hey, they're coming after me for $6,792. I From what I've seen on timeshare stuff, you're probably lucky that that's all they're coming after you for. Like, I know that feels like a lot of money, but like when we're talking about timeshare debt, that's actually not very big. And so what I would probably do is, I know you've talked to this company to try and exit the timeshare. I would probably be trying to just settle that thing, get on some kind of payment plan, use solo settle to negotiate for you, whatever. I think the thing you've got to remember in cases like this, I think you can get pretty upset that you feel like you've been treated unfairly, and frankly, you may have. But you want to be making sure that you're making like rational economic decisions more than you're making emotional decisions. Like to me, it's gonna feel real crappy writing a check to them when you feel like they've done this to you. But economically, it might be the best decision to just settle something like this.
Yeah, 6,000 certainly isn't the cost of a timeshare for 6 years, right? I mean, I'm not sure, but that seems pretty cheap for 6 years. I guess that's only
It's
$1,000 a
certainly a
year.
lower number than I've seen for the timeshare stuff that
Yeah.
I've
Yeah,
done.
I guess maybe $1,000 a year. Maybe that's a reasonable amount. Yeah, Wayne, you have a variety of options here, right? You have the scorched earth path, which is you fight it in court, you complain everywhere you possibly can about the timeshare, right? You have lots of options there. You have probably like the FTC, you have the Attorney General for your state, you have Google reviews, you have any other type of reviews, Trustpilot, etc. You have social media posts. You can complain everywhere available to you about timeshare. BBB is a good one as well. File a BBB complaint. That's like the scorched earth path, and then just try to defend yourself in court. Try to find some kind of legal loophole. Basically, you'd have to argue that they breached the contract somehow. Probably. Usually, a breach, what that might look like is the timeshare was unavailable when you wanted to use it, or like their software to schedule it was broken, something like that. Non-use is not a breach of contract, right? Just because you didn't use the timeshare, that won't be a breach of contract. And then on the other side of the spectrum, you can settle, right? You can just try to resolve this thing. Maybe you have $6,000 lying around. Most people don't, but you can try to offer them some amount, like maybe 3,000. They probably would take 3,000 or something, I think. They aren't out much money based on how I understand most of these timeshares work. And then you can try to be done with this. I think another key factor here is showing that you canceled, right? Make sure you have good documentation that you requested cancellation after the first month. If you want to do some legal research, you can look into what is required legally for cancellation from a timeshare. Greg, you ever looked into a timeshare?
It's not for me. I'll just say that.
One time I went to the circus. And they had a raffle out front of some sort, like some like digital thing. I entered my name as like you could win like a trip to Cabo or something. And I entered that, and we won something. I'm not sure if everybody won something, but we won something. And it was like 3 nights in Mexico somewhere, and all paid. All we had to do was show up at this meeting. So we went to the meeting. Meeting was a timeshare meeting. There was like a bunch of dudes who didn't look super happy with life, who were in like Hawaiian Hawaiian shirts and stuff. And we sat down in one room, and the guy drew a bunch of stuff on a whiteboard. And is like, "This is how much vacation will cost you." And then he said, "This is how much vacation will cost you through our timeshare program." And then we like cycled through a bunch of rooms. And then The hardest part of it was I watched some people make some really bad financial decisions. It seemed like some people were taking it really seriously. And we went in, we were just like ready, set to say no to everything. Right, our plan was to say no to absolutely everything, no matter how many times. Then I got to the final desk. There's the dude behind the desk. He's like the final closer. He's like, "Are we gonna sign you up?" I said no. I was like, "What about now?" I said, "No." "What about now?" I said, "Nope, still not buying it." He's like, "Okay, here is your free prize. Here's your trip to Cabo." And then we got the trip. We got the trip after all that, and I think they actually do pay for it. I think they're actually good for it.
Sounds
And
like you
then
got off easier than some people. I've heard some of
got
those
off
get
easier.
pretty nasty.
I mean, it was pretty intense. And then COVID hit, and we couldn't travel, so then that all fell through. We're never able to redeem that experience. But yeah, folks, timeshares range, right? That's one experience. Timeshare. On another experience, my family has a timeshare in a houseboat at Lake Powell, and that's a good time. It's like a timeshare is just run through an LLC, a private LLC of a group of people, and we do a timeshare that way. I've talked with one of a customer at Solo. He said he has a timeshare. Oh, who was that? I talked with an Uber driver. No, it was an enterprise. It was a driver that picked me up for like Uber or something like that. He told me that he has a timeshare that's cost him like $600 a year, and he gets to stay at this retreat for a whole like 2 weeks out of a year in Mexico. And he got into the timeshare in like the 80s. He's been going for decades. So that's a timeshare win. Timeshares come in all shapes and sizes. Some of them are really not good. Some of them are fine. Just got to use your discretion to figure out what's good. Let's see if Shuba, let's see if you are ready to go. Shuba's calling in once again. Shuba, are you there? Hello, hello. Can you hear me now? Looks like a no-go on Shuba. All right, we got some other questions from people who have written in ahead of time. So I'm going to pull up a recorded message right now.
Good afternoon. I used Solo to answer in a lawsuit from LVNN, $8,900 from Best Egg, and I immediately used Solo settlement, and we were going back and forth, but I'm on a fixed income, a Social Security. I can only afford $100 a month, and they want $300. And we've been going back and forth a couple times. And then all of a sudden, I said that I could do a lump sum payment, but not till May for $5,300. And I have not heard anything back from them. Settlement-wise, it's been approximately 2 weeks. What strategy do you think I should use?
Great. Greg, did you catch how much that lawsuit was for?
8,900. He said he could do a lump sum of 5,300 in May.
Yeah. Okay. Yeah. So thanks for calling in. So it sounds like you've been having success using Solo to respond to the lawsuit, then using Solo Settle to get the case settled. Sounds like it's going a little bit slower, a little bit more back and forth than you want here. What we found is that most cases that settle successfully, they usually only go through like 2 rounds of negotiation. So the consumer makes an offer, the collector responds, and the consumer accepts. Usually that's about as far as it goes, or the consumer makes an offer and the collector accepts. Sometimes cases do settle if there's a lot of back and forth. sometimes delays in negotiations is the real thing. Even when two attorneys are working together, things can take a little bit longer than you want. 8,900 is quite a bit. That's quite a large balance. At $100, I think their concern is that, so let's say it's $9,000. At $100 a month, it's going to take you 90 months. You pay that off, which is quite a while, which is 7 years. Right? So it's going to take you 7.5 years. So some parameters that collectors will oftentimes look at. Usually they don't want a payment plan to extend to more than 3 years. The longest we've seen is 10 years. We have seen 10-year payment plan. And then also the lowest collectors will usually go is about $100 a month. $200 a month is pretty normal. $300 a month is normal. $100 is pretty much their minimum. So you are at their minimum on a monthly amount, and you are beyond their maximum on a year number. So that's where things are probably falling apart here. If you're able to do on solo, you can do tiered payments. So if you could do a lump sum, right, let's say you could do like a lump sum of $3,000 right now, and then do $100 a month after that for 3 years, maybe that would get you across the finish line here. Those are my thoughts. You can also message the collector. Right? So you can message the collector through Solo. And besides that, I'd recommend sitting tight. Right? If there's a trial date set, maybe that's a while out. There's really might not be a rush. Nothing's going to really happen before the trial date. They can progress the lawsuit. You can just keep on responding to the documents that come up using Solo AI. Greg, you have further thoughts here?
Yeah. So he said that he has his $8,900 debt. He's at 100. They're at 300. They've kind of back and forth. And then he said, I can make a lump sum of $5,300, but not until May. And now they've gone silent on him. So I don't know what's happening there, but I can make an educated guess. So a lot of times when you are a debt collection attorney, the attorney does not technically make the decision on what the settlement amount is. That authority has to come from your client, who in this case is going to be the debt collector, right? So usually what happens, just to sort of streamline the process, when a debt collector gives a debt to an attorney, they'll say, here's the debt, it's $8,900, but here's what I'm willing to accept by way of settlement. So you don't need to come back to me and get the authority. I'll just tell you, like, I'll accept this or anything better than that. And then the attorney just has it. A lot of times, if you then if you're going back and forth and then you make an offer and then it goes silent for a little while, there's a pretty good chance that the attorney is like, well, I don't have authority on that. I got to go back to the client. And so because you're talking about these like small monthly payments, and then you come in with like, boom, this huge dollar amount, but it can't come in immediately. It may just mean the attorney has gone back to the client and said, hey, they're offering $5,300, but not until May. Are you willing to do that? And the attorney's just waiting for the client to get back to them before they respond to you. So I'm actually not surprised by that pattern. And I don't know that's what's happening, but just an educated guess is that's probably what's going on, and you may hear from them soon.
Right. Nice. That's a good take, right? So the attorney has to go and talk with the debt collector, their client, figure out if they can actually accept that deal. And that sounds about right? Because $5,300 on a $9,000 debt. It's not a bad deal for the collector. That's about 60%. The issue is that it's in 5 months from now, which is quite a while. Usually if it's like within 30 days, they'd probably say yes to that, no problem. If it's in 90 days, oftentimes the collector might be willing to say yes, but 6 months from now, 5 months, that's quite a while.
I'll tell you that if from the plaintiff's attorney's point of view, having been in that situation before, if I'm going back and it's like $300 a month, $100 a month, and then they come in hot with this huge amount of money, but I don't get it for 6 months, I'm probably going back to my client and saying, like, I know that you're not getting it soon, but you should really consider this, because 6 months from now, you're not going to have that much money no matter what if we don't take this deal. So it may be that they're mulling that over, because it is quite a ways out, but it's a pretty good offer.
But plus, it's a much better payday for the attorney.
Yes, and it very well may be that the attorney and the client are fighting about it right now. I mean, I don't know that, but just I've been in that situation a lot, and I'm sure something like that's going on behind the scenes.
Right. Okay. Well, that's a great take. All right, we've got time for just about one more question here. We've got Brian in Nevada who's written in. I'm being sued by Bankers Healthcare Group for a business loan. The judge already granted a partial summary judgment, but left questions about capacity, coercion, and loan terms. At the time of the loan, I was hospitalized for COVID and had impaired decision-making abilities along with chemotherapy lasting effects. Sorry to hear about the cancer going on here. Court ordered further discovery on this issue. I've been representing myself, but I'm going through cancer treatment and really need help. Should I keep fighting, or is now the time to leverage settlement?
You want me to go ahead?
Go ahead.
Okay. So I think it's important to note that there's probably not a right or wrong answer to this, and this is going to depend on what's right for you, right? And a lot of times, we talk about settlement, and it's like, oh, if you know you owe it, you should settle. Like there might be a lot of like non-legal or non-economic reasons to settle, right? Like going through a lawsuit can be, and having these debts hanging out there can be stressful. I know we've talked about a couple times tonight where, like, sometimes just settling can just get rid of this for you. And if you're going through something like chemotherapy, which is going to be its own stressful, tiring thing, having this debt on top of it, is it could potentially make it worse, I assume. So it might be something where even if you think you could win it, just for your own personal health, you may want to consider settling it. Now, as far as if you are going to fight it, what you're going to do is the judge is going to say, well, I might not make you pay this if you can show that you lacked capacity or they coerced you into signing it. So what I'm going to do is I'm going to prepare to go into that trial with proof of that. So what am I going to gather? I'm going to gather medical records, my own medical records that show that maybe I didn't, that I lacked capacity at that time. I might talk to one of my doctors and see, would you be willing to come in and testify on my behalf that I did lack capacity to enter into an agreement at that time? And those are the kind of things that you're going to need as proof at that trial. So again, I don't know that there's a right or wrong answer on should I fight this or should I settle. That's something that you've got to make, sit down and make a determination of. The fact that they only got partial summary judgment and not full summary judgment does mean you've got some leverage to settle. So you might now get a better settlement deal than you would have before they won the partial motion, because partial summary judgment means they lost part of it, or at least the judge deferred ruling on part of it. So that gives you maybe a little bit of leverage to try and negotiate something if that's the way you want to go.
Yeah. You know what I'm curious about here, Greg, is he says the judge granted partial summary judgment. Is that a thing?
Yeah. So what'll happen is sometimes you have to prove multiple things in summary judgment, right? So what they've done is they filed this motion and said, hey, we don't need to have a trial because it's not disputed. He owes the debt. So the judge could look at that and say, well, yeah, I'm going to grant partial summary judgment and say you did enter into a contract with them and that contract went unpaid. There's your partial summary judgment. But then he's going to say, but what I'm not going to rule on yet, and we need to have a trial on, is was there a defense of coercion or lack of capacity, something like that. So the judge wants to streamline the trial as much as possible. And we don't need to fight about whether this debt is actually owed or not. We only need to fight about whether you had capacity to enter into the debt. And so the trial is going to be focused on only that issue.
That's a pretty crazy situation. You don't see that very often, right? So I guess
Partial
this
summary
means
judgment is really common in court. It's not super common in debt collection cases.
it's quite common in like serious civil litigation, though. Yeah.
Yeah,
Public civil
when you're
litigation.
talking about like personal injury cases, you might see partial summary judgment a lot on like some claims and not other claims, or you might see it where, maybe there's a it's like, okay, I did owe a debt, but there's a dispute as to how much is owed. A court might say, okay, a partial summary judgment, there was a contract, the contract was breached, so I'm doing partial summary judgment on that, and all we're going to do at trial is figure out fight over how much is owed. Like that's another example of how that could come up.
Right. Well, I think the part that I think seems particularly crazy to me is coercion. Seems like the judge is giving credence to a coercion claim.
Yeah, and if the judge is already saying like, "Hey, that might be there might be a good chance you could win that because he's already thinking about it."
Yeah, I mean, coercion isn't very common. I mean, is it? Is it really? I don't think of coercion as being very common.
It's not very common, and I think it's something that's pretty hard to win.
Right, pretty hard to win.
Like, so the fact that the judge is already bringing this up, that's a good thing. And so if I've been a debt collector, I'm looking at it from the other side. If I go in my summary judgment motion and that's how the judge rules, I'm freaking out that I'm then going to go lose the rest of the case.
Yeah.
So that's why I say now's probably a good time to negotiate if you're inclined to do so.
Well, if there's coercion, there's probably a pretty serious counterclaim, right?
Yeah, or at the very least, the judge is going to throw the whole contract out.
Right. Yeah, folks, listening, right? Coercion is a situation where somebody like forces you to accept a deal. In this case, somebody like forced the listener to accept a loan somehow. Like maybe, I'm not sure, but I mean, it sounds like maybe the person had COVID and cancer, was in the hospital, and somehow was forced to accept a loan like in the hospital. That's kind of what it sounds like.
Probably something like that. I mean, the kind of like law school example would be like somebody has held your wife at gunpoint and said, "Sign this contract or I'm going to shoot her," and you sign it. Right? Like I'm sure that's not what's happened here, but like that's like a law school example of coercion.
Right. Yeah, and they don't usually. Yeah, in my experience, it doesn't usually actually happen. At least not
I've never actually seen it in all my years of doing this. I've never seen like a valid coercion claim.
Right, and duress is like even stronger, right? It's like duress and coercion, right? Usually like people kind of act like they have coercion, but usually there's not really any coercion. But the fact that the judge apparently opened the question about coercion in the summary judgment, in the partial summary judgment, sounds like maybe there's some credence to coercion, which sounds pretty interesting. All right.
Here's the other thing. Let me just add this real quick before, because they also talk about capacity. And so capacity is like, I didn't lack the mental capacity to make a decision to actually sign a contract. So what you're going to do is go in there with a medical opinion that you lacked capacity. Talk to your doctor, have him write a note, or even better, have him come into court. And what they're going to have to do at that point is, once you have the doctor's opinion that you lacked capacity, they are going to have to hire a doctor to come in and say that you did have capacity. And I think they are unlikely to do that. So like that might be a way to win this.
Tough things to get, I would imagine. Yeah, so those are some considerations, right? On the other hand, if you want to settle, now's always a good time to settle, pretty much, right? As long as you've like responded to the lawsuit, got that taken care of. Certainly settlement can be a good situation. Just kind of depends on more of your financial position here, Brian. All right, so those are some hot takes for everybody. Folks, this is the Debt Hotline. I'm George. We've been here with our guest, Greg Anjewierden. Greg, thanks so much for coming on.
Yeah, thanks for having me.
Folks, if you have any questions about debt, you can also ask about credit or improving your net worth, anything like that, anything finance, legal related. You can call into the Debt Hotline at 801-613-8181. All right, that is it for today's show.